Good afternoon, everybody. Attorney General Martha Coakley. On my right is Assistant Attorney General Jonathan Miller. On my left is the Chief of our Civil Rights Division, Maura Healy. These two attorneys have been the trial counsel for the Massachusetts Commonwealth challenge to the Defense of Marriage Act in federal court, and it was shortly to be in the First Circuit. I'm very pleased today to learn that the Department of Justice and President Obama have determined that the Federal Defense of Marriage Act is unconstitutional. This is a position that we have held and argued since we filed our lawsuit in federal district court here in July of 2009. We brought our case based upon a very firm conviction that to achieve marriage equality for all married couples in Massachusetts, we would have to ensure that all citizens enjoyed the same rights and protections under the Massachusetts Constitution and the U.S. Constitution, and argued that the Defense of Marriage Act was unsustainable when it was looked at closely. Today's decision, in the context of the Department of Justice decision and the letter that I believe you have or will have that was sent from the Office of the Attorney General, is another very important victory for all civil rights of same-sex couples and their families, as it means that the Defense of Marriage Act has now been declared discriminatory and unconstitutional by a federal judge here in Massachusetts based upon our lawsuit, the Department of Justice, and the President of the United States. A letter sent today from Attorney General Eric Holder informed Congress that it still has the ability, if it wishes to continue to defend these suits. And so exactly what that means for our suit pending in the First Circuit should become clearer in the next few days. I would note that our final briefs, our briefs before the First Circuit, were due next week on March 1st. We anticipate, or we've been informed, that the First Circuit will be informed by letter of the decision by the Department of Justice. We anticipate that that will be followed by a withdrawal of the briefs presently pending before the First Circuit, and that at a bare minimum we would look for an extension of time until it is resolved in what manner, if any, these suits would go forward. But we are pleased with this decision. We think that the reasoning, as expressed by General Holder, in some ways is dependent upon the extensive discovery and arguments that occurred in Massachusetts relating to the importance for Massachusetts of same-sex marriage, as our courts determined back in 2004, and that the Defense of Marriage Act had no basis, even under a rational basis theory, to be deemed constitutional. I'd be happy to answer questions anybody has.